I remember when, during pretrial questioning of one of my witnesses, I refused to get on the telephone with the court to decide an issue that the defense was having. You want to learn what this is about? Come join me as I share with you this great information. Hi, I'm Jerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. It's a beautiful day here today in Great Neck, and I want to share this great information with you. My client was being questioned by the defense attorneys as part of the litigation process known as a deposition. It's also a question and answer session. Legally, you may have heard the term examination before trial. And what it means is that the attorney has an opportunity to sit and ask my client questions in my office, and there's a court stenographer present who is taking down all the questions and all the answers that are being given. Now, during the course of this question and answer session, the defense attorney, in my opinion, was being totally obnoxious. And now they wanted to ask my client a key question. And the question clearly, in my opinion, was improper and called for an answer having nothing to do whatsoever with the issues in this case. In my opinion, it had nothing to do with the claims that we were making or the defenses that were being raised in this case by the defense attorneys. So now I'm getting into an argument with the defense attorney. He wants to ask a question. I'm telling him no. So he says, let's get a ruling from the court. I said, go right ahead. You can call the court. You can ask them anything you want. But I am not participating in that phone call. And he says, what do you mean? You have to. I said, can you show me where in the civil practice law and rules it says that I have to participate in a phone conference with you, with the court, if we have a dispute during pretrial testimony? And he was like, He's like, I'm calling the court anyway. I said, go right ahead. In fact, I'll dial a number for you. And that's what I did. And then I walked out of the room. So now I come back 10 minutes later, and he said, I spoke to the court clerk, I spoke to the law secretary, and they said if I have an issue, I have to make a motion on papers, a formal request to the judge to take any action based upon whatever issue we're having now. I said, fine. So why did you need me to participate in that? And you know what he said? He said, because I wanted to get a ruling right now so that we could proceed forward. I said, here's the problem. If I get on the phone with the court clerk, with the judge's law clerk, or even with the judge, the problem is the judge now has to decide a number of key things immediately on the telephone without having the benefit of knowing what went on before, without knowing the exact wording of your question, without knowing what the witness has testified to already, without knowing what the claims are in the case. And now the judge has to make an off-the-cuff ruling based upon the information he hears from each attorney in the span of 1 or 2 minutes. I said, that's not appropriate. You want to go ahead and make a request on papers and have documentation and have evidence from this testimony? Go right ahead. I'll be happy to reply on papers to your request. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what can go on during pretrial testimony in an attorney's office when a witness is being questioned. You know, I realize you're watching this because you have questions or concerns about your own particular matter. If you have legal questions, what I encourage you to do is pick up the phone and call me. These are questions I answer every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Jerry, G-E-R-R-Y, @oginski-law.com. That's it for today's quick video. I'm Jerry Oginski. Have a great day.